So Mia, if you want to
Sure.
start going into the case update.
Sure. So there are, as I said, a number of big decisions and then a number of decisions that put finer points on some of the smaller pieces that come up every day in our cases. The first case that I wanted to talk about was the Young decision. I think it's the most recent in time, but a very important case. That's 81 Northeast 3rd, 1165. It just came down last month. And that is a case that requires us to look at just the pre-separation lifestyle when determining the proper amount of alimony. So the SJC overturned a percentage-based alimony award, saying that the trial court improperly considered the wife's needs post-separation and improperly considered the husband's increased income after the divorce, saying that his income had been on an upward trajectory during the marriage and that they had increased their lifestyle during the marriage. And so the judge, and also because the husband's income was, in the judge's opinion, complicated and highly variable, he had 6 or 8 different components of his compensation. And the judge concluded that because it was complicated and highly variable, it was more appropriate to give the wife a percentage-based award on essentially the bulk of the components of his income moving forward. And the SJC essentially said it's unfair to give the wife a lifestyle that would be commensurate with what she would have had they stay married. That's not the appropriate standard. In other words, you're sort of locked into the pre-separation lifestyle, if you will. So I think that's a pretty critical piece of case law in terms of what we're looking at. And the court, as it had in prior cases, did make reference to the fact that a percentage-based award may be appropriate in a certain circumstance, but that is really the exception and not the rule. And there has to be pretty unique circumstances if you're going to have a percentage-based award. There was reference to that in the Hasse case, which was a case that we covered last year. But here there's a little more clarity to it. So the percentage-based award would be something, if you're going to tie it to a cost of living adjustment, or if the parties live in different countries and there are tax impacts associated with their various citizenship and tax reporting requirements. Things that are very specific might warrant a percentage-based award. But other than that, the court is saying that that we should disfavor percentage-based awards and instead look at how the parties lived at the time of separation, as opposed to giving the recipient the benefit of increased income post-divorce. I think the Young case is probably one of the more significant in terms of really what we're looking at and what we're considering on a needs basis. A little more clarity on that.
I absolutely agree. I mean, if you think about it, in a lot of your cases, and I don't know if you've found this yet, but when you've got a complaint for modification and say you represent the payor spouse and the child is emancipated or something has changed, and his income has gone up considerably, does the former spouse get the benefit of that increased income after the divorce? And I mean, truly, in multiple cases that I had prior to this case, the argument was, well, he has the ability to pay. But everyone was overlooking, okay, what's the definition of marital lifestyle? Marital lifestyle isn't the marital lifestyle that you enjoy after the divorce. It's what one enjoyed during the marriage, the standard of living during the marriage. So if you've got a client who is making more money and you're trying to reduce the alimony obligation, prior to the Young case, it was unsettled whether marital lifestyle actually meant that they get to continue, and even on arguments based on, well, it was known that, the husband was going to continue to increase in his earnings, and therefore former wife should get the benefit of that, as that was something that was done during a marital enterprise and partnership, etc. But this is huge. This, for both reasons. The marital lifestyle being defined as what they lived during the marriage, period, before separation, potentially, but absolutely during the marriage, not post-divorce. And so if you've got a client who is making more money, has a second spouse, et cetera, that shouldn't go to their ability to pay. You should still look at marital lifestyle first. And then the second issue, as Mia discussed, was the percentage-based awards. Now, on Hassie and other cases, they're not per se invalid, but here we are dealing with a statute that talks specifically about percentage-based awards, right? That there's a presumption that it's 30 to 35% the differential in the parties' respective incomes, the differential. And we've always done percentage-based awards. So it should be interesting to see that with other cases, other than the cost of living adjustment, et cetera, you're allowing someone with a percentage-based award, just as was argued in previous cases that we dealt with before, that a percentage-based award, when someone's income increases, the recipient spouse automatically gets increased alimony without there being a need to file a complaint for modification. So there's no need to show that they have an additional need. It was just automatically they would get more in alimony. The fact that they're saying that, okay, in rare exceptions, limited exceptions, a percentage-based award may be appropriate and warranted, assuming the court makes detailed findings of fact, et cetera. But that, for the most part, they are disfavored. And I think that's another huge point of the Young case.
And I think for me, when I was reading Young, for those of us who practiced way before the Alimony Reform Act came out, need was always the cornerstone, need and ability to pay. And you learned over the years of case law that need was based on the lifestyle that they both shared, the two parties shared during the marriage. And then the Alimony Reform Act came out, and you still have need there, but then they kept saying 30 to 35%. And so often, I know in my cases, I would try to argue, but maybe her need, typically her is the one receiving alimony, maybe her need is only 15%. And I think judges really shied away from that because they didn't have the guidance from Young. And I think what's really important to take away from Young, and it is in your case materials, is that they really focus on the detriment of the provider spouse when you're talking about need. We oftentimes focus on the recipient, what is the recipient's need, but you also have to think about need of the provider spouse. And this case really, really hones in on that and saying, okay, so maybe the marital lifestyle really was X amount that she should be receiving. But if she's receiving, and I'm still using the pronouns he, she, but if she's receiving X amount, but that is to the detriment of the provider spouse, that's going to be impermissible according to the Young case. And I think that's really huge because even before the Alimony Reform Act, I don't think we had that kind of hard and fast language from, this is from the SJC, but from even an appellate case saying, look, if this is what it is, then typically if this is what it is for the recipient spouse to live at that standard of living, that's the need, and therefore the payor spouse really just has to provide it. And oftentimes that was an unfortunate piece of advice that we'd have to give our clients. You're going to have to come up with it some way. You've been doing it for so long. And now this case really says, no, let's look to see if the payor spouse is going to be now, has a detriment to his or her life because of having to pay out. And I think the Young case really, really hones in on that factor.
And also what Young does, it really sort of gives you this way of looking at things in terms of a step-by-step analysis. So the court says the wife's need is an amount required to maintain the standard of living during the marriage, but that is not an absolute entitlement. In other words, if it's to a point where it's encroaching on the payor's ability to pay, as Julie had said, then you can't necessarily give the recipient spouse the standard during the marriage if it's going to unfairly encroach on the payor. And if that's the case, then that's when the court says there has to be a fair balance of the equities. Now, of course, there's no definition of what does that mean, fair balance. But it seems to me that what the court is suggesting is if you can't look at somebody's needs and there's not enough resources, once the households are split into two households, if there's not enough resources to keep the recipient at the same level, that's when you look at the 30 to 35% as an upper limit. So people ask us all the time, I'm sure the two of you as well, is it need or is it 30 to 35? That's sort of the eternal question when you're talking about amount. And it's the question that everybody has. And I think there's a little bit more clarity in the Young case, but it seems to me that the cases are really pointing us in the direction of if people lived below their means, in other words, if somebody made $500,000 a year, but they really lived on 200 and they put a lot of money away, then when you split the households, maybe each party can continue to live the way they did. But when you have people that lived above their means, when you split the households up, the recipient is simply not going to be able to live the way she did, and that's when you get kicked down to the 30 to 35%. I think that's well supported in the case law over the last few years. So that's sort of my interpretation of how we look at need versus 30 to 35, because the case law is not entirely, there's nothing definitive on that. But the Young case does give us the most direction that we've had in terms of looking at a proper amount. Another case that's actually really important that came down this year is the George case. That's 476 Mass 65. And that is a deviation case, and deviation is something that we have to confront in a lot of our cases because the law as it is doesn't necessarily seem to apply to everybody's cases. So you say, well, I've got a special circumstance. I should get more alimony, or my alimony should last longer. And it happens to all of us. So the George case goes through what's called the interest of justice standard. What does that really mean? What do you need from an evidentiary perspective to satisfy the interest of justice? And what does the court need to do if they're going to deviate from the restrictions in the order? The George case set out that the recipient spouse bears the burden of proving by a preponderance of evidence that deviation beyond the presumptive termination date is required. So that's a pretty significant standard. The George case gives us the here and now focus, and not necessarily looking at what the situation was at the time of the divorce, but more we have to look at where are these people today? What are their economic circumstances today? We look at the here and now. The only time the court, according to George, is going to look back at what the factors were at the time of the divorce, and I'm talking about obviously in a modification proceeding, is if there were factors that existed at the time of the divorce that continue to exist and continue to have an impact post-divorce, such as if somebody's health, they had a health problem at the time of the divorce that continues on into the modification period, and it continues to significantly impact somebody's resources, whether that's on the income-producing side or the increased expenses side. George says in those cases, we will look at the circumstances at the divorce. Other than that, we're looking at sort of the modification. What are the circumstances today? Does somebody have more income, more expenses, less income, fewer expenses? So all of those pieces are really, George is sort of shifting us into looking at where we are now and not necessarily where people were at the time of the divorce. Another important case that came down is the Snow case, 476 Mass 425. That case gave us quite a bit of clarity on a new alimony request that came upon after the divorce, and essentially the court is saying that that the new circumstances are relevant, and that actually Snow gave us some pretty interesting pieces in terms of looking at overtime income that was new, and we had always looked at that as saying, well, if we looked at it more in the child support context. It's very clear in child support that if somebody picks up an overtime or a second job and they do that after the entry of the order, that the court is not required to take that new income into consideration. And that kind of same concept applies in the Snow case. The other thing about the Snow case that's really instructive to us, I think, is the health insurance discussion. There is quite a bit of discussion in the case about the importance of health insurance and how we look at the cost of health insurance when setting alimony orders. The court recognizes that there's somewhat of an inconsistency between the pre-Reform Act approach toward health insurance in that the cost of the health insurance is relevant to setting the amount of alimony under the statutory factors, but then the Reform Act essentially requires us to consider the cost. So either the inconsistency being, we used to look at it and say, well, it's inappropriate to reduce somebody's obligation just because they're paying for health insurance, but yet we must consider the cost of the obligation. So how do you marry those two pieces? But I think Snow is important in terms of giving us quite a bit of detail on how the court has to look at this and how the court must make findings regarding health insurance.
Also on Snow, and I know that Mia's going to go into sort of the juxtaposition between Snow and Floor, which are really interesting cases, and they're both in your materials. But I think something that Snow does, and Mia just mentioned it about overtime. Remember, if you're in this, let me back up. Snow and Floor deal with modifications or dealing with either initial alimony awards or modification of existing alimony awards. So, and there's a difference in the Alimony Reform Act on whether you deal with overtime income on those kinds of cases or not. When it's an initial alimony award, you're going to be including all income. You're going to be including someone's overtime pay. And Snow says that because even though it's a modification case, it was the first time the wife had dealt with alimony. So even if it's a modification, it doesn't mean that it's not an initial alimony award. In the Alimony Reform Act, if it's a modification where you already have an alimony order and someone's going back to modify that order, you're not going to include their overtime income if they have taken on the overtime work in order to afford the existing order. I know that's confusing. Does anybody have questions just on that one point? Yes.
To state it differently, overtime is included if the payor is receiving it before the divorce. If
No.
the payor gets it,
Doesn't necessarily have to be before the divorce, and I think that's the interesting thing in Snow. So she was the recipient wife, had already been divorced by the time you get to Snow, and she was requesting alimony for the first time in a modification action. And so let's just look at it this way. Anytime there's an initial award of alimony, overtime's always looked at and included in income. If it's a modification of an existing alimony order and someone is earning overtime just to pay on the existing order, then it's not included in the calculation. It is confusing, so I would urge you to read Snow and Floor both.
Well, Snow was a different case in
Fair.
many respects. I mean, coming from New York, she had been divorced 4 years before she filed in Massachusetts for a modification. And in the modification, she sought alimony. So the SJC had to determine what's the appropriate time. Like, is this an initial order, an existing order, or was this dealt with in the prior judgment? In New York, it was never dealt with. So there was nothing.
Silent.
Right, so there was a judgment that never addressed alimony. So that's like if we had a separation agreement that never addressed alimony, period.
Which we wouldn't.
Right.
But just
The
hypothetically.
wife did not participate in
In
the
the-
New York divorce, and that really is what makes the Snow case
Exactly.
very different. She didn't show up for the proceedings, apparently she had filed some claim for alimony early on in the divorce, but didn't pursue it. So it was just, the judgment was just silent. I think Snow is troubling to us, at least it was to me, for a number of reasons. But
Definitely, and I had judges rely on Snow in stating that in a modification where, and you're going to get into Floor, but it was a misinterpretation of the Snow case. And until Floor came out, it was pretty scary. And that's going to be a case on appeal. But it's really the determination of, under the durational limits, under 49B, when do they start to run? If alimony was awarded, not on the date of the divorce judgment or date of, so Snow talked about the fact that if the divorce judgment is silent and doesn't deal with alimony, there's no alimony award, so it hasn't begun to run.
So it's
Right.
therefore setting an initial alimony award, even if you ask for it in a modification case. Don't let the term modification deter you from thinking this could still be an initial alimony award, okay? Because it could have been silent in the initial judgment. So if it's an initial calculation, an initial setting of an alimony award, you are definitely going to look at overtime income. That was the only point I was trying to make. I know that Mia says a lot more to go through in her case law update. But if there was already an alimony award, and you're looking to modify it, then you're not going to look at the payor's overtime income if they obtained overtime in order to pay the existing award.
But what if they paid overtime not to? do the
Well, that would
existing
be
award?
something you'd have to prove,
Right.
right? You'd have to prove that he or she only got overtime just to, pay for Christmas presents or something, but yeah, just to make more money.
So there's a question from the webcast audience. How do you square the Young focus on the premarital lifestyle with the George, quote, "here and now," end quote, in a post-act modification?
Good question. Same thing occurred to me when I was reading the case law, saying, well, just, how do you marry those two pieces, if you will? It's challenging because of the circumstances that change after a divorce. People have health issues, they have income increases, so although the court is saying, oh no, we must look back at the standard during the marriage and you're locked into that, another further complicating factor is if there's child support that's ordered at the time that then goes away over time. It's challenging to reconcile those two concepts, truly.
Well, other than just briefly, the Young case was an initial, again, it goes back to,
The Young
case
was
is
an
an
initial
initial
order.
divorce.
Yes.
George is in a modification, so George, the court in that case was saying, in order to modify, you're looking at the here and now. In Young, they're saying, you're in the middle of your divorce case, and you are looking at the standard of living that the parties enjoyed during their marriage. So there are two different considerations because of where you are in the cases. In Young, you were right then getting divorced. In George, they've already been divorced and someone's coming back asking to change something.
Right. And that's another piece as well, as some of the cases make, significant clarity and give us clarity between initial orders and modifying and what standards we use, and also when the initial order was set. So obviously, again, we're seeing confirmation again that if it's a pre-Reform Act order, you're using the old standards, if you will, when you're modifying the numbers, as opposed to post-Reform Act orders, we're using the new standards when we look at modifying. I think that's basically
That's huge.
very clear at this point.
Yes.
Can I ask a question? Just on what constitutes initial alimony. As you mentioned, the child support alimony conundrum, and there's some judges that say, okay, the two of you together make $150,000, I'm considering it all for child support, so I will not issue alimony. Kids grow up, child support ends, wife comes back and says, okay, no child support now, I want to ask for alimony. Would that be considered initial alimony? Because she asked for it before but was denied, but now she's...
Well, there is case law on that we now have, where the child support went away and the wife came back and sought alimony. You'd obviously have to look at the wording of the agreement and so forth in the particular circumstance you're talking about. But what the court would look at, and what the court did say, is that they didn't order the alimony just on the loss of child support, that they ordered alimony in consideration of income and expenses of both parties and financial resources of both parties at that time. And so I think if you were just going to hang your hat on, well, I've lost my child support, now I need alimony, I think that the court would disfavor that type of straightforward argument. But when there are the other factors in play of expenses, needs, and income shifts, and asset shifts, then the court is able to say, well, we're not just looking at the loss of child support.
And just
Would
because
that
she-
be considered an initial, would they be looking at it as an initial alimony award, because they never ordered it before?
I think again, if you look at Snow, Snow was very strange because it was literally silent. I think there's a difference in a judgment being silent versus just saying, you don't get it right now.
Okay.
Those are two very different things. Also, there is case law, and Mia would know more than I do right now on this one, but that talks about, you're not going to go beyond what the initial award would have been. So if child support is actually running longer than what the alimony award would have been, then the alimony is not even going to be possible for that person to go back and get. So for example, if the kids are emancipating, say, in 15 years, but you only have alimony running for 10 years, the recipient spouse can't go back at year 16 and say, now I don't have child support anymore, I want alimony, because that timing would have been off. So there's a lot of different considerations than just an initial alimony award or not.
And so we have to try to repeat the question, but, so, I think the question and the general gist is, if you have a separation agreement that talks about
But I was thinking of an order, not a separation agreement.
a temporary order or a judgment.
Judgment, but there was not an agreement, and the judge said, I'm not ordering alimony because I'm ordering like, all the income was used up to determine child support. And he didn't buy the other arguments, but why you could do it that way.
As long as I think the judgment stated that there was some fact-finding about there's no award for alimony, as this is a strict guidelines case, therefore, alimony is merged, and that's where it would be a modification of an existing
Order.
judgment or order that basically doesn't provide for present alimony. Because in these cases, as we do in our separation agreements, so the waiver of past and present alimony, that's sufficient to say
Right.
that's
But again,
the
saying,
initial
there are
order.
lots of cases that there's no agreement, it's just the judge's order. So that was.
And I think in those cases, if it's not clear enough, you would have to file a motion for clarification and/or some
Or just
type.
argue it.
Just so that you're protecting your client down the road.
Well, not if your client's.
True, depending upon who you represent.
Who's not getting an alimony because of a meeting of the Senate.
You had a question?
I was going to say, when you draft an agreement, should you have select some de minimis amount of alimony in there just to protect yourself?
So the question is, when you draft an agreement, do you have some de minimis amount of alimony in the separation agreement to protect yourself? And that's a great question, because before Floor came down, the interpretation of Snow effectively meant that no one would ever want to pay just child support, because you wouldn't be protecting yourself by giving yourself the protection of the durational limits. You would pay some portion as alimony.
So you start the clock
Right,
running.
right. So, but I think Floor, which we're going to get into, addresses that, as long as there's sufficient language.
But I wouldn't include an amount. Number one, I think the court would be hard pressed to approve an agreement like that without findings and understanding why that amount was there. I would always, and I do always, include, if there is any possibility for alimony, I always put a date that it cannot go beyond X. Whatever that is under your calculations for the length of the marriage and the durational amounts. I would always put in there that in any event, the recipient spouse is not going to go back and try to get alimony after this, whether it's the date or something else that you want to calculate it by.
Or if the other side is not agreeable to something very specific like that, at a bare minimum, put the duration of the marriage, that they were married on such and such, and the complaint was served on such and such. And make sure that's all memorialized in your documents, because you'd be amazed at how many times we're scrambling back through old
Can't
divorce
find the
files.
summons.
Can't find the summons, can't find the date, so it's hard to calculate the duration on things like that. But while we're on that subject, we should,
Sorry, if you have the duration part survive in an agreement, but you anticipate that there maybe there's no alimony at the time of the divorce, but you anticipate increase of income and alimony at a future time, and you want the alimony amount to merge, how do you deal with the survival versus merge, where you don't want to, you want to be clear that it's going to end at a certain date?
So we haven't, yeah, sure. So I think the question is that if you are trying to survive the duration, in other words, you're trying to fix the duration and say this is the maximum length of time that alimony is ever going to be paid, no matter when it starts being paid, but yet you're anticipating changes in income moving forward, so you don't want to survive the amount. I think that's concerning, because right now, there's not a lot of clarity in how that would be interpreted on a modification basis. And what the statute is saying is, if there's an agreement that survives in part on alimony, all of the alimony terms survive. I think that's the general interpretation of the statute right now, without any further clarity on that. I know we used to write alimony provisions quite frequently where we would survive the termination date, essentially what you're talking about doing, but we would leave the amount to merge over time, and none of those, to my knowledge, have gone up to the appeals court yet, but.
Same here, I've done the same thing. I've survived the durational amount and let the other part merge if, that's what the parties wanted to do.
Right.
Could you address that by doing, I know the percentages is an issue now for a court ruling, but for a separation agreement, could you deal with that by having survival completely, but having percentage amounts of incomes, or no? Like just having, just having a percentage of the difference in the party's income, that's the alimony survives. Say alimony is going to be a straight 5 years, survives. It's now 0, but it's going to be this percentage of the party's income, year 1, 2, 3, 4, 5.
And have that survive?
Have the whole thing survive. Is that a way to get around?
I don't
Because
know.
I'm
I
just
would
nervous
advise a
about
client
having
of
the
that.
combo merge and survive.
Right, because that
Sure.
could very well be interpreted as surviving. I mean, if people are agreeable to those kinds of terms, I think, they're really rolling the dice on something like that. But I guess there are circumstances where if it's a short-term obligation, somebody's willing to say, look, if I do really well in that short term, I'm happy to share that with my spouse. Or if I don't do well, that's what's fair.
Or you could have an income, a cap. You could have a cap on it rather than a percentage that it would go to directly. Sometimes a lot of times I use caps if it's someone, if a payor spouse, I'm representing the payor spouse, and they have additional income from other types of benefits, whether it's commissions or bonuses or things like that. You might do a cap on that kind of income instead of just saying it will go to X percent. You could always do a cap to keep it under a certain amount. And that could survive. I think that even advising someone to do an increase to a certain percentage could get you in a lot of trouble as an attorney. If that income is not absolute in those future years.
On the cap, just while we're on the subject of the cap, I think the caps are really helpful when you're negotiating higher income support orders, because we now have young, and we now have sort of this is the standard of living that you had during the marriage. This is what you're locked into. You're not going to be riding somebody's coattails into the future. So, I think people come into the divorce situation and say, well, I was home doing this, taking care of the kids, and making it so that he could do what he's doing now and what he's going to continue to do, and why is it that I'm locked into this fixed level? And so that's when the caps are sometimes helpful, because it is a way of sort of covering if somebody's income does go significantly higher. And the cap, of course, could either be a cap in any amount that the recipient receives, or you could base the cap on income levels. Mm-hmm. So if a certain income level is achieved, anything earned over that is the earners to keep, if you will. And I'm sure you've probably done things where you're applying income over a certain level toward kids' expenses. That's something that oftentimes helps us settle cases, because it's much more palatable for people to think, well, I don't mind paying for education, but I don't want to pay for her. It's that kind of a concept. So we'll often shift excess income to college, or even other accounts for children, for the benefit of kids directly.
And going on Mia's point, thanks to the Young case, I think it's going to be easier for us to try to negotiate with opposing counsel those caps.
And with our clients. A lot of times, I have, some clients where, oftentimes it's the wife and the husband makes $2 million a year, but she doesn't need even 30% of that to maintain her lifestyle. So, we actually have sort of a basis than just saying, look, the judge will never do this, or look, the other side's never going to agree to this. We now have sort of a baseline to be able to say, this is really commensurate with your need and your lifestyle, and we actually have something to point to.
I'm sorry, you had a question?
Sort of a reverse way of looking at this, with a person, a wife with serious medical problems, written into the agreement, acknowledging the fact that she has health problems and she's contributing to the child support, with the child now emancipated, would that then trigger the fact that it was already contemplated that there would be an increase once the child was emancipated and she no longer contributed to child support? Then would go back to the alimony which you have been receiving, and then circumvent all the cases, essentially jump in at the percentage of 30 to 35%?
Do you want to repeat that?
I don't think.
Well, I think, I'll try to repeat it. The reason I'm repeating that question is because there are online viewers/listeners, so they can't hear you. I think the gist of the question is, if you were to write into a separation agreement that wife, for example, has particular medical needs, and therefore it may be contemplated at the end of child support, she will need alimony, without actually writing that in there? Is that what you're saying, that you're actually admitting to these medical needs and therefore it's contemplated that she may need it?
In the need for alimony, and the basis being that since she's been contributing reduced alimony because of child support, that when it's modified, instead of dealing with the cases that we're talking about, it just jumps back into the percentage of 30 to 35%.
And the rest of the question for the online audience is that, would it then just jump back into the 30 to 35%? My quick answer to that is no. I don't think it's ever going to be an automatic jumping back into anything unless you actually have that number written in there. If it's an agreement and it sounds like you're writing it in, it's going to be automatic without having to return to court anyway. Now, at the beginning of your question, I have tried to do that on separation agreements and literally saying these are the considerations and these will be his or her needs in the future. I think it only helps a modification case that you have in the future, but I don't think anything is going to be is going to fully protect you unless you write in the actual amount and the date in which it's going to become automatic, because then you have to go back to court anyway on a modification complaint, and then you're still going to have to prove your case then. I think it helps you prove your case if you detail what the medical needs are, but no matter what, unless you have an exact date and an exact amount, you're going to have to file a complaint for modification and still make those arguments.
We should probably talk briefly about the Floor case, right, since we had been talking about snow. The Floor case is 92 Mass App 360.
It is in your materials too.
Yes. And so that was the case, and we had sort of made reference to it, of long-term marriage, and in the divorce agreement, the wife reserved the right to seek future alimony. She had waived past and present. She brought a complaint for alimony in the anticipation of the loss of child support when the children were about to emancipate. She was age 56 and the husband was 59 at the time. The court ordered alimony for an indefinite term and not terminating at the full retirement age. And the reasoning behind it was that this is really a pre-Reform Act alimony obligation, so we're looking at the old standards under which alimony does not necessarily terminate at full retirement. And the court felt that it was unreasonable for the ex-husband to expect that his support obligation would end when child support ended, because the wife specifically reserved the right to seek future alimony. So in the Floor case, that is a circumstance when I think when you first read the Floor case, you say, wait a minute, this doesn't seem fair. But when you look at the overall circumstances and you don't just pull apart the reservation of future alimony and you look at the other pieces of this, in considering not only the loss of child support, but the wife's overall circumstances, like the court really wanted to do the right thing for the wife and looked at her situation. And the husband made arguments in the Floor case that the wife really had not maximized her employment opportunities. But the modification court essentially did attribute income to the wife, but still found that despite the attribution of income to her, that still wasn't going to be enough to meet her needs. So there's an interesting discussion in the Floor case about attribution of income, and on the interplay between child support and alimony and the factors that are considered. So that is an important decision to read. Do you want to add anything further on Floor?
Yeah, on Floor, I just thought it was really interesting that because this agreement and judgment were before the Alimony Reform Act, it was being modified outside of the confines of the Alimony Reform Act. That was something that, before these few cases came out, I had thought about modifications within the Alimony Reform Act. And, obviously you have to read the act and see where you're deviating and how you're modifying. But this case makes it very clear that if the award, like in this particular case in Floor, the award of general term alimony was entered prior to the act, you're going to modify it according to the laws outside of the act. So before the act, you're going to pretend like the act doesn't even exist, basically, and modify it. So then you're just going to have your general change in circumstance type standard of review.
So even if the alimony award is nothing more than to say, I reserve the right to future alimony, that's going to be considered a prior alimony consideration.
And the Floor case also goes into, in cases where alimony was not contemplated at the judgment of divorce, it goes back to the Snow case, but it distinguishes it and says that treating complaints for modification in such cases are initial complaints for alimony, like in Snow. However, the controlling precedent in Floor was the Buckley case, that it was a separation agreement where the parties waived future alimony. I should say waived past and present alimony, but future alimony was
Left open.
merged.
Right.
So that's the issue of when does the durational limits start?
The next case I wanted to mention is the Emery versus Sturdivant case, which is 91 Mass. App 502, which is a really interesting discussion about attribution of income, probably the most in-depth I've seen in a while. That is a case in which the husband, after a long-term marriage, was in administration of a private boarding school, and his compensation, including his direct compensation and all of the benefits that he received, housing and vehicle and tuition, were substantial. And just prior to the divorce, he resigned his position, and the court really looked at the circumstances under which he resigned, why he resigned, and what he did after he resigned. So the court found that he had engaged in what it's calling reasonable job search efforts. There's a lot of discussion about what that standard is, what it means, how you look at it, how you present it factually. That's, I think, quite compelling. But in the Emery versus Sturdivant case, the husband not only engaged in a fairly aggressive job search after resigning, but he also tried to mitigate the loss of income with consulting income. And the court felt that he had engaged in good faith efforts, and distinguished cases in where the court has found that there was a lack of good faith. And so cases where people were purposely not accepting employment at a certain level, cases where people had completely switched careers to a much lower paying career. The court is essentially saying that's not what this man did. He essentially continued to aggressively search for employment consistent with his prior level, and he attempted to mitigate the damage. So the court did find that the support should be based on his actual income instead of the attributed prior high earning level that he had before he resigned his position.
To me, this case is really important because before this case, you may recall, and I can't remember the name of the case, I know it's a Judge Kagan case in the lower court, but really we always went by voluntary versus involuntary change of income. And I've actually had people call me up to say, hey, I want to change jobs, but I have this existing alimony or child support order. I want to just change because I'm too stressed out. And I say, oh my gosh, don't do that. Don't change because you're going to be held to this unless it's an involuntary change. That was always the standard that we looked at. I think this case is so important because we see someone resigning for different reasons, still good faith reasons, and even though it was a voluntary change, it's now no longer just to look at voluntary versus involuntary. It might still be voluntary, that's what the court says. It's clearly a voluntary change, and his income did decrease, but he was doing all of these other, making good faith efforts to keep up his income as much as he could, to continue doing what he was supposed to be doing under the judgment for his other obligations, and then the court didn't say, oh, it's just voluntary, therefore we're going to go ahead and impute all this income to you, which is very different than what we've seen in past case law.
Right. The other thing that's interesting about Emery versus Sturdivant is that the court made it quite clear that that it can modify alimony prior to service of a complaint for modification. So that's a pretty substantial departure from the way we sort of look at how we're going to modify things. It did make the distinction that you can't modify retroactively prior to service of complaint on child support, but that you can do it when it comes to alimony. And I think essentially what the court was trying to do is rectify what the trial court did in requiring the husband to pay alimony at his prior earnings by saying he resigned, he made good faith efforts to replace his income at the level it was at. He wasn't able to do that, but he did do his best to try to improve his financial circumstances. It's unfair to stick him with the high alimony obligation, which when his incomes went down significantly, the arrears racked up very quickly. And it was a big arrears number, which the court essentially said it's unfair to require him to pay that. So that's a little bit unusual that we're seeing on modification
I mean, the case is
retroactively.
definitely unusual for a number of reasons, including that waiting judgment, there were complaints for modification already filed, complaint for contempt. I mean, there were multiple judges involved, and he did resign, quote-unquote, due to personal reasons, but that was as a result of having engaged in an extramarital affair with a subordinate. So, I mean, was it voluntary, involuntary? Well, it's certainly as a result of his own actions. So, but really, the appellate court focused on what you need to show and the fact that he made this effort and did what he needed to do to look for a job consistent with his prior earning capacity and just couldn't find one. But it's definitely very interesting.
Another piece that is sort of an evidentiary piece, and we'll get into it a little bit more because there's a number of newer cases that discuss the evidentiary standards, but in this particular case, what the appeals court said is that there's no evidence that his job at the prior income level was available indefinitely. So that almost suggests that now we have to go in and prove that a job is going to be available indefinitely. I'm not sure how you could ever prove that. Nobody's job is ever available indefinitely. And in this case, the husband did have a history of contract renewal. I think he had 3-year contracts that were renewed consecutively. And even before the separation, he was in contract talks to have a renewal. So, requiring the wife to prove that the job was available at the same level indefinitely, I think is an unreasonable implication there. The court stopped short of saying that, but I think what they were saying is no proof that that job was going to be available long-term. Another case that I think is pretty significant this year is Ludwig versus Lemmy Ludwig. And that is a case in which, again, a somewhat narrow set of circumstances where the parties at the time of the divorce resolved all of their issues between them by agreement, with the exception of the issue of whether the husband's income from stock options that were not divided in the divorce, whether that income could be factored into his alimony obligation. And the second issue was what date would be an appropriate date to use for the valuation of his stock options. So they came up with an agreement that resolved everything except those two issues, which they put before the judge in a summary fashion. And the judge essentially came down and said that the income from the stock options that were not divided under the time rule formula can be considered in the husband's income. I'll just briefly, we're not talking about asset division here, but essentially this relates to the Bacanti versus Morton time rule that we use in dividing unvested stock options, which essentially is a formula that is trying to capture the unvested equity that somebody has received, that even if it isn't fully vested, that under the application of a time formula, it is partially vested. So what the court is saying here is to give the wife income, a piece of the income that's generated by those options that isn't divided is not double dipping, because those options in fact were not divided. I think there's a fine line made in here about double dipping, and when we look at assets as, somebody waiving their right to assets, or can you look at the asset and still consider the income stream from it for alimony purposes? The court spends a fair bit of time distinguishing that, and essentially says, if there's an asset that can be segregated into different pieces, and we can use part of it for assets and part of it for an income stream, then it's not impermissible double dipping. The double dipping as a matter of course is disfavored, but it's not always inappropriate if there can be different components. And here the court said, well, some components of his options were divided under the Bacanti formula, and the wife benefited from those. But to those that weren't divided, the income that is generated by those, even though the wife may have already received an interest in the other piece of the options, the income generated by the options not divided is on the table.
As a practice tip, this was the Judge Casey case in the trial court level. I had a case this year with the exact same issues, brought this case up in front of him, we were arguing it, and he still wants to follow this. So just so you know, he still fully believes in what he did, and I frankly think he was correct in this case, as did the appellate court think he was correct. So basically, kind of what we're dealing with here is oftentimes you will have a payor spouse who has to pay child support and alimony, but he also wants to keep his stock oftentimes. So this is a way to say, okay, you can keep your stock, but I'm going to include it in the alimony or child support that you are going to be paying. And it helps, sort of resolve some of those asset division versus what is your income type arguments. And Judge Casey still, at least in the case that I had in front of him, still thinks that this is kind of how he likes to do it. So if you have a Judge Casey case, you have issues like this, stock versus, vested versus unvested versus alimony versus how are we going to divide the assets. This is something that he still does, and I think it's a good idea.
So when you draft something like this with stock options, it behooves us, I think, to delineate what's an asset, what's income, and break it down like you just described. Would that be something the panel endorses?
Yes, the question for the online audience is this something to detail in a separation agreement, for example, how you're defining income versus assets, right?
Yes.
Yes, I think it is a good idea, especially if you are dealing with things like, okay, we have X amount for alimony. How do we arrive at this? What did we include as their alimony, or what do we include as their income for alimony calculation? And yes, I would absolutely include it in a separation agreement. It's also good because when you want to go back in the future for modification purposes, if that payor spouse still has stock or is receiving stock in the future, I think you could at least base an argument on saying, hey, we've always calculated it like this and we did it at the time of the divorce. I mean, it doesn't necessarily mean it will have to happen that way in the future, but I think it's a good argument.
Absolutely. The only other thing that I wanted to mention about the Ludwig case is that the court spent some time discussing data valuation of the options. The husband wanted them valued as of the time of separation, and the wife wanted them valued as of the time of the divorce, and the court went with the valuation at the time of the divorce and discussed why, and essentially concluded that the wife had continued to contribute to those assets by essentially being the primary caretaker. I'm not sure under that standard how you could ever say somebody didn't contribute during the period of while the divorce is ongoing. But that's really nothing new to us. I think it's unusual to win on an argument saying that you want to divide assets at any other than the date of the divorce. To try to get assets divided on a prior date is an uphill burden that is only successful under very narrow circumstances, in my experience.
Agreed.
The other thing I want to distinguish about the Ludwig case is that there's another case in the materials, although it's a 128 decision, but that also deals with income from stock options. But in that matter, it was in a child support calculation that was being discussed. And what the court essentially said is even though the wife waived her right to various stock options in the divorce, that she couldn't possibly have waived the children's right to support based on income generated by those options. So that's the distinction there. If you're an adult and you're dealing with alimony, you can waive all you want. If you're talking child support, you have no ability to waive your children's rights to support. So that is and that's a distinction that's been consistent, I think, throughout case law. The next case that I wanted to mention is this Fern Cappuccino versus Cappuccino. I don't know if I'm saying that the right way, but that is 90 Mass App 525. That is a child support case, but I included it in the materials because there's a number of discussions in there that are relevant to alimony considerations as well. One being contribution from household members, how you look at those pieces, what factors are relevant to the contribution analysis. The other piece that's relevant is the double dipping discussion, which of course is relevant to alimony as we've been talking about. And also the court references attribution of income in this case as well, again, relevant to alimony. There's a footnote 14 in the Cappuccino case that gives some detail regarding imputation of income and what factors the court looks at in some detail, which I think is something that applies to a lot of the cases we all deal with on a regular basis. What the court is essentially saying is even if if somebody has the ability to work, that the judge cannot necessarily attribute income at a certain level at a very specific amount of hours or per week without some indication that that work is available. So the lower court attributed income at a rate of 30 hours per week at a set hourly rate that the wife had said, well, in the past I've had a job consulting making X amount per hour. And the court said, well, then I'm going to use that X per hour at 30 a week. And the appeals court said, there's no indication in the record that 30 hours a week was available, so it's not appropriate to attribute that level of earnings to the wife. And again, child support case, but the same concepts would be applicable in an alimony argument.
Is that the cappuccino?
Yep, Cappuccino.
I think that's important too as another practice tip. It's not necessarily saying that the imputation of income wouldn't have happened if there was evidence that, in this particular case, it was about the mom's employer had reduced her hours, and there was no evidence that those hours were available to her. So you can't just take X times 30 or 40 hours a week. You have to say, would that employer have given her additional hours had she asked? You know, there's some people's employer would say, no, I wouldn't give it to you because I don't have the money, or I don't need you to work here for that X amount of hours. And as we all know, there are other people who purposefully reduce their hours even though their employer would want them to come back. So I think that's something important if you're going to be going to trial on that case, to get whether it's their employment agreements, their requests. A lot of times we have people who are nurses, get their requests for additional hours, their per diem, rates, their hours, their schedules, their time clocks. I think those are all important factors if you're going to be taking the case like this to trial, so you can have that evidence to show the court it's possible, it's there. He or she is just choosing to not take on those hours. And then you'll have, I think, what the court would need to actually impute the income to someone.
And another piece that in the Cappuccino case that was referenced is the fact that the appeals court felt that the lower court sort of overlooked the wife's obligations to care for the 4 children and said essentially this consumes a significant amount of her time, and that the father only has the kids every other weekend, so she's doing the bulk of the child care. So some recognition of the obligation that comes with being the primary care parent for that much of her time for 4 children, which I think is worth mentioning as well. There were a number of 128 decisions that I included in the materials because in one way or another I thought they had some pertinent discussions. The first one is, a number of them actually on issues that we don't often see come up. There were a few of them that deal with conduct-related, a disproportionate asset division and alimony awards, support awards, essentially referring to various misconduct, if you will, and how that impacted the marital estate and how it impacted spouses. So that's a little bit different because we don't often see conduct cases. There's also a case in the 128 decisions, what we haven't seen in a long time, which was a countervailing equities case where parties had surviving obligations. And despite the surviving obligations, the court modified them. We don't see that often, but specifically in the order, I think in the order in which they're in the materials, Pickering versus Mendez is the first 128 decision. And that has a pretty good discussion on the evidentiary standards regarding proving health and medical problems. So although the wife did not provide documentation of her health problems, she did apparently testify in some detail regarding her health issues and the impact that that has had on her ability to work and her expenses, and the court found those credible. Her health had deteriorated since the divorce. Her food expenses had actually gone up because of her health issues. She had had unstable housing over time. She'd gone from a number of different housing environments that were the court considered unsuitable. And also in that case, she had lost, the child support had gone away. So essentially the judge considered all of those factors, looked at all of those factors, as well as the husband's increased income and his decreased expenses since the time of the divorce. The Cournoyer case, C-O-U-R-N-O-Y-E-R, which is at 91 Mass. App. 1125. This case was decided before the George decision came down. So essentially there was reference to, well, if we had looked at George and the judge had had the benefit of the George decision, we probably wouldn't have seen the same judgment from the trial court level. But this is another case that I just wanted to mention the reference, because there's two of the newer cases both say that the trial court is not, it's not an appropriate inquiry to look at where, what bargain people might have struck had they known that their alimony would have ended. So in other words, it's not an appropriate thing to say, well, had she known that her alimony was going to end, perhaps she would have done things differently. So the court is rejecting that sort of look back and saying, you know, let's look at the here and now. We can't look at what they would have done at the time. And I think that's, you know, entirely appropriate under the newer cases that we're seeing now, because if that were the case, then there would never be any application of the durational provisions, at least, because people would always say, well, had I known my alimony was going to end, I would have bargained for a different division of the assets.
And that's been, that point has been one of the flashpoints on whether the Reform Act should apply retroactively or not, because on both sides of the ledger, the payor and the payee spouse have said, well, I wouldn't have done X if I had known my alimony was going to end, and it's unfair to apply it retroactively, or not apply it retroactively.
Right.
So this,
The duration.
Again, right, so this, I guess this Cournoyer case addresses that.
Yes, yes. What this case, and it's an interesting read because the court deviated from the durational limit, but picked an arbitrary end date for the alimony. So that's interesting as well. Like, why did you pick that date? It wasn't a retirement date. It wasn't the durational date. So the court is essentially saying if the lower court is going to pick a date, there has to be some basis for it. There has to be findings that are detailed and a rationale for it. And just picking arbitrary dates is not going to be upheld if it's challenged. The court in that case really looked at what it considered to be a vast disparity between the parties' respective circumstances at the time of the modification. So the wife's circumstances, as I mentioned, had declined significantly due to health and other considerations, and the husband's hadn't. So I think that some of these cases you see the judge is trying to fit the set of facts into the law a little bit, which I think is unfortunately, how our world exists, where every case that comes into us has a different set of facts and compelling circumstances, and that's the trick, is to look at the case law, pull out the pieces of the cases that are relevant to you, and think about how you're going to present that evidence. The White versus Harmon case, which is 91 Mass App 1104, talks about attribution of income again. And also, what I thought was a really interesting discussion regarding looking at attributing income in the context of somebody who owns their own business. So this husband, in this case, post-divorce, had claimed that his salary had decreased, but the court looked in significant detail at what else was going on. They looked at his profit and loss statements, court looked at his revenue, his adjusted gross income after salary to employees, looked at the payment of personal expenses that he was paying through the business, and also looked at his lifestyle. How is he living? And we often go into court and say, well, but Judge, he's still living this way, and he's still doing these things. And so in this case, the court really looked at those pieces and said, we don't necessarily believe that the husband's income has gone down because there's all these other pieces. And we don't, not just going to look at his salary, because as a business owner, he obviously can control the level of salary that he's taking. So the court, I think, did a good job at looking at those other factors and making findings regarding those other factors. The other discussion in the White versus Harmon case is about cohabitation. The wife was looking for an extension of the length of the marriage under the alimony discussion for the fact that they had lived together 19 months before they got married. And this court is saying we're going to look at the cohabitation law provisions under the Alimony Reform Act to see whether there really was an economic partnership sufficient to include premarital cohabitation. So I think that's the first time we've really seen a lot of definition on looking at whether we consider premarital cohabitation timeframe when we're looking at the duration of a marriage. So the court is saying, look at the cohabitation language we have in our statute and the factors that we've set out there in determining whether there's been an economic partnership before the date of the marriage. The Trodden case, Trodden, all of these cases are now, they're all 128 decisions. That's 92 Mass App 1106, is the countervailing equities case that I mentioned, which again we don't see very often, but surviving agreement modified. The trial court reduced the former husband's surviving alimony obligation because he had suffered a pretty significant disability. Didn't terminate his alimony, but reduced it by 28%. So the court essentially said you've suffered a pretty significant and unanticipated reduction in your income, which was health-related, and I think he had had surgeries, and so he literally couldn't do the same job that he had been doing. And so the court reduced but did not terminate his surviving alimony, and essentially looked at the fact that he would have had to spend down a significant amount of his assets to maintain the same alimony level, and the court felt that that was not a fair thing to do. In the Worthen case, Worthen, 1 Mass App 1106, this is the case that I referenced earlier where there was a distinction between option income for alimony versus child support purposes, but that's a good discussion of how the court's going to look at income from in a post-divorce event, such as sale of stock, that the wife waived her interest. And in that case, the wife waived her interest in certain stock that the husband had. She claimed that it was ambiguous as to whether or not she waived her interest in it, and the court essentially said the fact that you disagree with the interpretation of the agreement doesn't make it ambiguous. And the Larkin-Thompson case, which is 92 Mass App 1103, I think a fairly narrow set of facts, but another discussion regarding conduct and how that's going to impact the financial terms of a divorce. In that case, the husband had a long-term relationship and a child with another woman, that he concealed from his wife and spent a significant amount of money in pursuit of that relationship, including purchase of a large home with his girlfriend that he then put essentially in his girlfriend's name, spending on $70,000 vacations and a $400,000 boat. So the numbers in this situation were fairly extreme in that case. In addition, when the wife found out about this long-term affair, she suffered some pretty significant emotional setbacks that affected her long-term. So those pieces, in the eyes of the court, warranted a disproportionate division, which on paper appeared to be a 55-45, but when you factor in all the debt that the husband assigned to the wife assigned to the husband, it essentially came out to a 75-25 division. Essentially, looking at the big numbers that the husband had spent, I think really more of a conduct and a moral discussion more often than we usually see, and more often than we usually hear in probate court, in terms of clients that come into us and say, well, this is what's happened, and isn't this unfair? And we sympathize, but we sort of always know that that argument is not going to get very far. When it's extreme like this, and it's quantifiable like this, it is something that was upheld as being reasonable. On the notion of conduct, the Estasio decision, ESTACIO 91 Mass App 1129, another conduct case, long-term marriage. Trial court gave the wife 60% of the assets. Husband had been drug trafficking, and she lost her job as a result of the fallout from his arrest. He gave her a sexually transmitted disease, multiple affairs, same type of thing where the court really focused on his misconduct, if you will, and the impact that it had on the marriage, on the wife's earnings, and on their assets. The Turner case, 92 Mass App 1108, is a discussion about deviation and deviation from durational limits. And the appeals court felt that the lower court improperly attributed income, that the judge failed to list cohabitation as the husband argued that the trial court failed to list cohabitation as a basis for future termination. In that case, once the George decision came down, the Turner case, in its focus on the fact the wife had essentially made the argument of, had I known my alimony would end, I would have argued, or I would have accepted a different asset division. George essentially put an end to those types of arguments, as I mentioned earlier. One other case, Rediger versus White, which is a fairly lengthy 128 decision, that's 1 Mass App 1111. There's some interesting language in that case, but one of the pieces that I'll mention just briefly is that the wife, after the trial, submitted a proposed judgment that had certain provisions relating to the termination of her alimony and calculation of alimony, and the court adopted those, and then she later challenged those pieces on appeal, and the court said, well, you put it in your proposed findings, and all the trial court did was follow your proposed findings, so you can't now challenge those pieces of the judgment. So I think that's a lesson to the wise. Be careful about your proposed judgment and proposed pleadings that you put in after the trial.
Absolutely. Thank you, Mia, that was great. We're going to take a break now. Again, I know we're going off the schedule, but if we can resume at 4:05, and then we'll talk about grounds for deviation.